Being the first point of contact for litigants in the country, trial courts play a pivotal role in the justice delivery system. Still, very little is talked about them when it comes to bringing in reforms in the judiciary, with the focus mainly being either on the high courts or the Supreme Court. Except for piecemeal conversations around the acute shortage of judges, there's hardly any meaningful deliberations or discussions that take place with regard to the real concerns troubling the subordinate judiciary in India. And that is exactly what this new book intends to do. Titled Tareekh Pe Justice, this book is actually, it gives an independent and a very deep assessment of the problems that are plaguing the trial courts, and also it actually also shows that why the trial courts today are in a mess. And to talk more about it, we have Prashant Reddy T and Chitrakashi Jain, who have together co-authored this book. Welcome to the print, Prashant and Chitrakashi. So I have read the book, and I think you've dealt with the issue in a very comprehensive manner. But, I would like to acknowledge one thing, that whatever you've written is not really new to me. It doesn't really come as a surprise to me, considering that I have covered trial courts extensively. Your book actually gives authenticity to what I term as, corridor gossip about why trial court judges in India are under fear, under some sort of pressure, and maybe are unable to deliver justice speedily. Let's I want to restrict myself to that only. So why is there a delay? So of course we will go into the actual contents of the book, but first, from I would like to know from both of you, what really provoked you to write this book. Was there any particular incident, or was there anything that you have come across, any experience? So why did you think of writing on the trial courts? Because there's hardly anything which is really written on it so far.
Yeah. First of all, thanks for having us, Bhadra. Just to give some background, about 5, 6 years ago, both of us were working at the think tank, Vidhi Center for Legal Policy in the Judicial Reforms team. So, which is where we started working initially on, how the district courts were working.
Yeah.
And what struck us was the fact that there is almost nothing written on the district courts. There's an isolated law commission reports which covered some minor aspects. So, which is why after we had left the think tank, we were mulling over the issue, and we decided that there's a need to do a deeper dive into the workings of the district court, and that's where this is how this book project came about.
So during that period, when you were doing your research, what really struck you about the trial courts?
Well, the it's in the first few chapters where we've covered how the disciplinary mechanism works. That is what came as a complete surprise to us.
Okay.
I mean, despite having researched, focusing on the legal system and researching on it, our focus has always been on the higher judiciary. And we had no idea how the district judiciary was being investigated and disciplined by the high courts. And we were just amazed to see how arbitrarily the system works, wherein these district court judges don't have even some basic rights when it comes to being investigated by high court judges. It's a very opaque system. It's not transparent.
Yeah.
And it doesn't give them a guarantee of a fair inquiry.
So we'll just come on that point. But first, I would just like to tell our viewers, that your book is primarily divided into three portions. So while the first portion focuses on the judges, right, their fears, as you just mentioned, the arbitrariness in the disciplinary proceedings, in the way they are removed. The second part talks about the role of the Supreme Court and High Courts, where you are actually saying that there's some sort of an accountability needs to be fixed. Now, why it needs to be fixed, I'll ask a specific question to you about it. And then in the third section, you've talked about reforms, right? The structural reforms. And of course, there's one more part, I think, the fourth, where you've spoken about the importance of procedural law, right? So I think for our viewers, for the first part is obviously the most important because that directly, in a way impacts them. All of us know that how trial courts in India are actually reeling under pressure because of the growing pendency of cases. I think it's more than 4 crores, if I'm not mistaken. And along with that, we also know that we hardly have any judges in the trial courts to give speedy justice, which way, whichever way, whether it's this side, this way, or that way. So now, during your research, which of course you have encapsulated very well in the first part, during your research you have found that there are a lot of problems with regard to the appointment, the transfer, evaluation, and disciplinary proceedings. So can you just give us some, a bit of insight into this? Chitrakshi, can you
Yeah.
start? Can I start with you?
Sure. So, in the first part, we do unpack the way the high courts administer the district courts, especially when it comes to disciplinary processes. Most of the conversation on judicial independence also has been restricted to the independence of the higher judiciary. But what we discovered during the course of our research was that, in fact, district court judges are not secure in their jobs because they are subjected to multiple ways in which their performance is reviewed, and also they do not have immunity even for the judgments that they write, which
Hmm.
was the discovery that shocked us the most.
Hmm.
We found that many a times disciplinary action is taken against district court judges on flimsy charges where there is no proven misconduct or corruption, for reasons for granting bail too frequently or granting bail in too many cases,
Hmm.
or questioning the choice of sentencing, or questioning the compensation they've given in civil cases. So they are not completely immune
Hmm.
for the judgments they make on the judicial side also.
Hmm. Hmm.
And this is in contrast to all the other jurisdictions where in the UK or in the United States of America, where the judges are completely secure for the judgments that they write. They have full immunity. Uh, of course, disciplinary action should be taken when there is a proven cause,
Right.
but they have complete immunity about the judgments that they write unless it is accompanied by
Right.
a corruption
So
charge.
are you suggesting that trial court judges can actually face disciplinary proceedings for writing a judgment? Is that so? For writing a judgment which may not be, acceptable to either one of the two sides.
So their legal reasoning becomes a factor in the disciplinary action. We
Okay.
found cases in which the high courts have said that there is no probable way to decipher whether an extraneous consideration was exchanged for the judgment,
Mm-hmm.
but just the fact that they granted bail too frequently could be a charge enough, and that is a discretion that a judge has.
So, Prashant, I think what I can understand and gather is that while a judge delivers a judgment, so on the judicial side, the judgment can be challenged before a higher forum. Then why should a judge be penalized on the administrative side for that particular judgment? Is that a question which you're trying to raise through your book or through your research?
Yes, that's one of the main points that we try to raise. In contrast to, the Supreme Court judgments or High Court judgments where there have been instances where the Supreme Court has gotten judgments completely wrong. It
Mm-hmm.
has had to recall them because riots broke out.
Yeah.
For example, the judgment on, diluting the Prevention of SCST Act.
Yeah.
When that happened, there was no politician asking for the impeachment of the judge because there's a tacit acceptance amongst the political class that if there's an error in judgment, that's not a reason to ask for an impeachment of a judge.
Mm-hmm.
But for some reason, the same logic doesn't flow down when it comes to the district judiciary.
Mm-hmm.
There is a particularly shocking case in Uttar Pradesh where a district judge was charged uh, in a disciplinary inquiry because she gave very generous compensation in a land acquisition case. So the way the charge was framed was that your reasoning in this case has contradicted another one of your judgments
Mm-hmm.
while calculating a compensation in a land acquisition case. And hence, it is we presume that for extraneous considerations, you have granted this enhanced compensation. And the judge had to fight for 16 years before she got back her job.
Mm-hmm.
I mean, this kind of approach to disciplinary issues
Right.
has a chilling effect on judges unless there is proof of misconduct,
Right.
such as, say, corruption, bias, something like that. Judges should not be subject to any kind of disciplinary inquiries. An appellate court exists specifically to correct errors in or legal errors of judgment.
So another shocking thing which I really found was that as far as the disciplinary inquiries are concerned with regard to the trial court judges, you do not have a uniform system, or you do not have uniform guidelines for all the trial courts in India. These trial courts actually, they work in accordance to the specific state rules. Is that so?
Yes, I mean, that's another thing that surprised us. Basically, all the judges of the district judiciary are considered to be employees of the
The
state
state.
government, and hence the same civil service rules that apply to the bureaucracy, the civil services of the state, also apply to the judges. So, for example, the district judiciary in Delhi is subject to the All India service rules, which also govern the conduct of IPS officers and IAS officers. And this is a completely incorrect framework to be using, because the job of a judge is completely different from the job of a bureaucrat. This is a colonial hangover which we just forgot to fix after independence. If you
Right.
wanted to create an independent judiciary, they need specific safeguards, because the concern is not only pressure from the government, the concern is whoever wields the disciplinary power, in this case the high courts, may also exercise pressure on these judges.
Right.
So, what we call decisional independence of a judge must be protected by giving him adequate safeguards against whoever wields power over them.
So the safeguards which we are talking about should be similar to the ones that have been given to High Court judges and the Supreme Court judges, right? Which is a constitutional protection.
Yes, I mean, to the extent that perhaps we don't recommend a system of impeachment, because that is just, it doesn't work
Too
out
cumbersome.
properly. But there are examples from other countries where you have independent judicial commissions separate from the high courts, where the process is more transparent, and there are sufficient safeguards given to the district judiciary, because the most important thing is to assure them that if there is a complaint, they will get a fair hearing. Because the moment they see one of their colleagues being hauled up and fired for granting bail too liberally on the basis of evidentiary rules that are a joke, then the entire district judiciary will freeze. They will not grant bail in
So
difficult
I want
cases.
to I want to point out the two words which you've used, fair and transparent. So why do you say that the present system of holding disciplinary proceedings is not fair, is unfair, and is also not transparent? In your research, what did you really find that actually gives this suggestion?
See, on the issue of fairness,
Yeah.
one of the main things that bothered us while we were researching this for this book is that when it comes to allegations of corruption, there need to be clear-cut rules of evidence. Now,
That are missing as of now.
that
So
are
they don't
missing.
follow any rules when it comes to holding an inquiry.
Exactly. So hearsay statements are admitted regularly in these kind of hearings. And hearsay meaning that is generally, if there's a victim of a crime where a judge has granted bail, the victim's family will complain saying that this judge has received a bribe to grant bail. But they aren't able to produce any evidence, because it's the rumor mill in the village or the community
Right.
that has told them that this judge has gotten, uh, you know, a bribe. Now, how do you hearsay evidence is generally very unreliable, right?
Yeah.
And in trial courts, for example, in judicial proceedings governed by the Evidence Act, there is no question of a hearsay statement being admitted. But in disciplinary inquiries, they're regularly admitted, and the charge is framed around the hearsay statement. How do you expect a judge to defend himself against something which, a hearsay statement where he doesn't even know who to confront? So these are one of the many issues in how evidentiary, strong rules of evidence need to be clear,
Okay.
so that only high quality evidence is admitted in the proceedings.
Okay.
And on the transparency point, perhaps
Chitrakshi, would you like
Sure.
to? Yeah.
So we did collect a lot of information. We tried collecting a lot of information by filing RTI applications to the high courts. And we also wanted to figure out what is the trigger for these disciplinary inquiries, and we phrased a question to that effect. And we found, I mean, not only did the high courts refuse to give us this information, we do not actually know, there is no publicly available information that tells us what is the threshold on which these inquiries are triggered. For
Mm-hmm.
example, the Bombay High Court received close to 4,000 complaints, vigilance complaints against judges of the district judiciary in Maharashtra. It acted only on a very limited set of complaints, but we do not know what is the distinguishing factor in those complaints that
Okay,
the High
why
Court
some were
chose
not
to.
taken up and why some were
So
dealt
we
with?
don't know what the threshold is because
Hmm.
these rules are not publicly available. This entire process is very opaque
Mm-hmm.
and governed by the High Court bureaucracy, which is also staffed by district judges. So there
Yeah,
is a position registrar vigilance,
yeah.
which conducts these inquiries and wields a lot of power against the district judges.
Yeah, yeah. So, my next question is that do these judges, do they have any platform where they can go and address their grievance, or that is, or there is none for them?
That's one of the big
Yeah.
problems, because the entire disciplinary mechanism within the High Court is controlled by High Court judges. So there's an administrative committee which makes recommendations based on an inquiry, and then that recommendation is confirmed by the full court of judges,
Yeah,
which has all the judges of the High Court.
yeah,
Now, when a district judge is his only course of action once he's dismissed or
yeah.
there's some disciplinary action is to file a writ petition before the
Yes.
very same High Court against the order taken by the full court of that High Court
On the judicial
on the
side.
judicial side.
Hmm.
So he's basically asking the judges to reconsider their own decision on the judicial side. So the lack of an independent review mechanism
Mm-hmm.
is one of the biggest problems,
Mm-hmm.
because how often are judges going to admit that they have been wrong on the
I,
On the
in fact, I
administrative
administrative
was
side?
side.
going to ask you this only. My next question was that, okay, fine, you have a mechanism that is you can approach a high court on the judicial side, but how effective is that mechanism and what has been the response?
It has not been very effective, because one of the trends that we saw is with these judges, the district judge who's seeking a remedy before the High Court, he has to file a writ petition under
Right.
Article 226,
Challenging an administrative
challenging
decision.
an administrative decision. And very often the High Courts will say that we are not a court of appeal, because under Article 226 we can only exercise limited review,
Oh,
which is generally a review limited to whether procedure has been followed. Now and then there will be that adventurous judge who can see that it's been so egregious on the administrative side that
needs
they
a.
will intervene and set aside the order. And there are a few cases like that, because these cases also stretch out for years,
So
right? So
how often are these kind of cases? What does your research show?
unfortunately, we don't
Don't
have
have the
accurate
statistics.
statistics,
Okay.
because even when we ask for statistics, were not being given. So some high courts shared statistics.
Mm-hmm.
And for example, Madhya Pradesh and Rajasthan didn't give us even the number of disciplinary inquiries that they
Okay.
were initiating. And that itself is a problem.
Yeah.
Right.
In every other country, the number of complaints received, the number of inquiries, and the kind of action taken is published proactively by the judiciary.
Okay, which is missing in our country. So it
Yeah.
is very difficult to even access the data with regard to trial courts or just, I mean, or subordinate judiciary,
The
right?
Exactly.
judiciary or
And
the commission which is in charge of conducting those inquiries. So they
Yeah.
will proactively make that information public.
yeah.
So you have been able to really, base your research on the judgments that were available to you on the public domain, right?
Yes.
So whatever research you did was on the basis of the judgments. Now, during this, I just want to know one thing that, okay, fine, as we just talked about, that there is a, I mean, okay, fine, it may not be the perfect review mechanism, but there is a review mechanism available for now on the judicial side where a district judge who's removed, terminated, can challenge an administrative order before a high court. But you believe and you suggest that it is not very successful. Is it so?
Yes, it isn't.
Okay. Now, but for how long do these proceedings really remain in the High Court? So, even if judges say, suppose they succeed in convincing the High Courts on the judicial side that what has been done with us is wrong, to what extent is that success really meaningful for them?
Exactly. A lot of these cases go
For
on for, like
decades.
we said, there was one case which went on for 17 years before the judge got her job back. There were other cases which routinely cross 10 years. Again, we don't have hard statistics. There, like in Madras High Court, we've seen there's a tendency to deal with these cases faster.
Mm-hmm.
So within 1 or 2 years, the petition at least will be disposed.
Mm-hmm.
In other high courts, especially in Allahabad and Patna,
Yeah.
we have seen cases drag out for close to a decade easily.
Okay.
There's a case in
Okay.
Gujarat which went on for 21
Oh my
years,
God.
right?
And what happened in that case? Did the judge finally win
The
or
judge
lose?
won. He got his
So, but
job
so
back.
that's exactly my point. So, after 21 years,
Exactly.
even if the judge won the case, is it
It's
really a meaningful
yeah.
victory for the judge or not? Yeah.
It's not a meaningful victory for the judge, and more importantly, what's the message that is going out to the other judges? That's what
Yes.
we should be equally worried about.
Right. Now, so the next question is about that only. So, what kind of an impact does it have on the litigants of this country, on the citizens? How is this entire opaque procedure, which is not even fair, how is it really impacting them?
So, one of the examples I think is the great bail crisis that we are seeing in this
Yes.
country, where the Supreme Court of the country has to decide close to 21,000 bail applications last year. So, when the district judiciary realizes that bail applications, granting bail in difficult cases, is attracting disciplinary inquiries from high courts, their natural reaction is to not give bail on the first instance in most cases.
Okay.
And that's a phenomena across the country. You speak to lawyers, they will say that a first bail application is almost guaranteed to be rejected
Mm-hmm.
if the crime is even slightly serious.
Mm-hmm.
And then the second or third bail application will be maybe allowed. If the crime is really serious, even that won't happen.
Mm-hmm.
So that is one of the manifestations. But our broader hypothesis is that all cases which the district judge deems to be risky
Yeah.
from the perspective of attracting a disciplinary inquiry,
Yeah.
they will do their best to
To
not hear
avoid
those
them.
cases
Yeah.
because these guys are being transferred every 3 years.
Mm-hmm.
So they just have to game the system in a in a smart way
Mm-hmm.
wherein they can avoid deciding these difficult cases. They
Right.
just have to wait for the next transfer and
Mm-hmm.
they rotate out.
And I think this is exactly what you say in chapter 4, the curse of the revolving docket. Is that so, Chitrakshi? Is this the
And perhaps the litigant will be more familiar with this side because they experience the judge being routinely changed and they were having to conduct the whole proceeding again. So perhaps the litigant is more familiar with transfers than what happens when a judge is withholding a decision or trying to avoid a more difficult case,
Mhm.
because with the transfers the judge has the incentive to just leave the caseload, especially cases which are more difficult to decide, and move on to the next charge that they have been given.
Right.
And this is the exact reason why judges are not really taking control of their courtrooms either, because they are constantly being outsiders in new
So
scenarios.
is this actually the cause of pendency and delay in disposal of cases rather than the acute shortage of judges? Do you think that this is the real cause?
This is this we suspect is the more probable cause for delay than shortage of judges, because that shortage is anyway limited to very few states.
Hmm.
It's not an all India problem. Some states do very poorly in recruiting judges on time, the others do not. uh,
Okay.
so this is the more probable cause for delay, and especially in deciding cases that are more difficult by judges.
By judges. So basically, it's a fear factor which is now in play.
Fear partly, and partly no one
The
wants to do
Yeah.
complicated work, right?
Hmm.
So we have found circulars from the Allahabad High Court going back to 1932,
Hmm.
where the High Court is making observations that we have noticed that the easier cases are being disposed, while the more complicated cases are going behind in the queue.
Hmm.
And whenever an additional court is created,
Yeah.
all the complicated cases are handed over to that new additional court where a new judge is coming.
So
So
another reason why maybe the judges are not keen to handle or hear complicated case, of course, fear is one factor, is the manner in which I think the judges are marked,
yes.
the ACRs. So is that also the reason why the judges do not want to hear complicated cases and just want to do away with the easy ones that are easy to be decided?
Yes, bingo. I think you hit the nail on the head because if I can just explain how the assessment system works for the viewers. So there's basically a unit-based system wherein every judicial task is marked as a certain number of units. For example, if a judge oversees a cross-examination, he may be given 2 units. And at the end of every quarter, a judge has to meet a minimum number of units in terms of judicial tasks. Plus, he needs to dispose a certain number of cases. That's how the performance assessment system works. And he has to get a good rating, otherwise, there are consequences that follow later on that we discuss in the book. So, the problem with this unit based system is that it is not linked to time,
Okay.
right? Because what is scarce in the courtroom is judicial time. So whether a judge now is overseeing an easy cross examination or a complex cross examination, he's getting the same number of units. And similarly, whether he's disposing a complicated case or an easy case, he's getting the similar number of
Similar.
units.
Yeah.
For example, if it's a murder case with 10 witnesses or a murder case with one witness, he's getting the same kind of this thing. So, as as a salaried employee,
Right.
your natural incentive then is let me pick the easiest cases because I also need to worry about my performance assessment. I need to meet these disposal units before I'm transferred, or there's an intra district portfolio transfer. Because we've seen in states like Uttar Pradesh, not only are judges transferred within districts, within the same districts, every few months, their portfolio is changing
Changes.
from
Yes.
civil to criminal.
Yes. Yes.
So these judges are they're dealing with so much uncertainty
Right.
that the system is pushing them also in a certain way to decide the easiest cases.
Got it.
And this is what we suspect is happening. Like if there was more data available, I'm sure I
You'd
have
have
a pretty
gone
good
deeper
feeling this
into it.
hypothesis will be confirmed.
Yeah. I want to come to the next part of your book, where you were talking about the role of the Supreme Court and High Courts, and you say that some sort of an accountability must be fixed because you believe, or maybe your research has made you believe that it is basically, it is like supreme. I won't say that they're really responsible for it, but in some way or the other, they have contributed to the mess which the lower judiciary is in today. So, can you just give a bit of more insight into this? Why do you say that?
Well, I mean, for one reason, the high courts are in charge of judicial administration throughout the state, and they just don't do a very good job. For example, something as simple as judicial statistics. We don't have accurate judicial statistics in this country. We don't believe the data on the National Judicial Data Grid is accurate because there's a big disclaimer on that website saying
Okay.
that this data is not verified.
Okay.
And we have our own hypothesis in the book on how flawed the data is. So when all these tasks are being controlled by administrative committees of high courts, of high court judges. So whether it is recruitment, procurement, infrastructure, there are administrative committees of high court judges sitting to make these decisions, which involve the expenditure of public money, and there is zero transparency in how these committees function. The minutes of the committees are not released. The Bombay High Court has released an elaborate judgment where they said we don't have to share it even under the RTI Act. So these are crucial decisions being taken by judges, and we have zero visibility into how this entire system is
Crucial
working.
decisions with regard to the functioning of the trial courts,
Yes.
right? With regard to their operations, which that has a direct bearing on our citizens.
Exactly.
The
And-
other, yeah. The other way the Supreme Court has also intervened is through the way it makes policy on judicial reforms on its judicial side.
Yeah.
So there have been multiple public interest litigations by bodies of judges associations, in which the Supreme Court has intervened and then recommended reforms, which has also compromised the way in which state governments and high courts negotiate these reforms. So the Supreme Court has centralized these reforms and made it applicable to all states. So the choice of site, choosing a courtroom to make policy is also questionable.
Okay, so what according to you is the way ahead? How do you think we can really resolve this crisis right now, which our trial court judiciary is in today? I mean, what is the way ahead for them? Because I mean, as I introduced, for every litigant trial courts are actually, the first step towards seeking justice. And if they're not able to get justice in time at that stage, so what is really left for them?
Exactly. I mean, so one piece of the problem is obviously the disciplinary issue, which needs to be outsourced to a full time commission which works in a transparent manner. We need to build back the confidence of the district judiciary that they will get a fair hearing in case there are complaints against them. The other piece of this problem is on the administrative side, where we don't think that this current system of high court judges sitting part time on committees and part time in the courtroom is
Yes.
working. These are complex issues, they need full time professionals.
Mm-hmm.
To that extent, we seriously need to think of professionalizing judicial administration by creating a separate office. It can be under the control of the judiciary
Yeah.
to ensure judicial independence,
Independence. Yeah.
but it has to be run full time by professionals, like managing infrastructure projects, human resources development.
Mm-hmm.
These are complicated issues.
Mm-hmm.
It is unfair of us to expect high court judges to
Mm-hmm.
do this part time while they're also running their courtroom. It
Mm-hmm.
just does not work out.
Right.
So the entire administrative system needs to be overhauled. And most importantly, we need a system of accurate judicial statistics. We used to have a system of great judicial statistics back when the British were ruling us, ironically, where
Mm-hmm.
you get exceptionally accurate statistics
Mm-hmm.
and a disclosure on how public money was being spent by the judiciary.
Mm-hmm.
So the one solution that we propose is actually a bill that the late Fali Nariman had proposed in 2003 when he was a nominated member of parliament in the Rajya Sabha, called the Judicial Statistics Bill. It's a
Mm-hmm.
very simple requirement mandating the judiciary to publish and certify the accuracy of its workload and the case pendency. Because once you have statistics, you can then have accountability. You can also have better planning and management of public money on how it is being spent for judicial uh,
Right.
for to manage the courts.
Right. I just want to ask one more question. I know it is not, directly linked to the book, but there is a lot of debate around All India Judicial Services. Do you think that is one of the solutions? Do we really need to have one cadre for the entire country, where judges for the trial court are hired through one common entrance?
Absolutely not. This is an idea born out of the emergency. Let's not forget that the
Okay.
42nd Amendment had introduced this in
Yeah.
Article 312,
Yes.
and it applies only for the district judges. It doesn't apply to the
To the
lower
lower
two
two. Yes.
tiers.
Yes.
And the problem is we have a report on this we had written earlier when we were working at the Reddy Center for Legal Policy, where basically we say it's a solution looking for a problem, as in we
Okay.
don't know what exactly they want to solve with this,
Okay.
because it is not the case that all states have vacancies at the district court level. Many of them have enough district court judges, but most importantly, the proponents of the AIJs
Mm-hmm.
do not answer the question of language,
Yes.
because when you're when a judge is sitting in the courtroom, it is very different from an IAS officer who's coming from one state to another, because judges need to have near native proficiency in the state language,
Mm-hmm.
because most states the courts function in the local language,
Mm-hmm.
and judges have to interact directly with witnesses. It's not like an IAS officer who's a managerial cadre who's dealing only with other bureaucrats.
Right.
So and the stakes here are immense, right? You're talking about the life and liberty of a person. A mistranslation here and
I
there has
agree.
grave implications.
I agree. I agree.
So, on that count, it's a bad idea. And most importantly, most state governments are not in favor of the AIJS, because justice delivery is a very sensitive issue nowadays in the country, especially northeastern states, which have they have very unique legal systems even within the framework of the Indian Constitution. They are extremely worried about outsiders coming in to decide, disputes that are affecting their people.
Right. So I want to ask one last question, Chitrakshi. Maybe you can throw some light on it. Whenever discussions take place around the lower judiciary, so there's always one thing which comes into play is the role of the state governments, because it is often there is a major complaint which we get to hear, that the state governments do not do enough to provide or to improve infrastructure in the lower judiciary. So, while doing your research, did you come across any such sort of data where you felt that this is correct or not? Or in such a scenario, what do you think is the role of a high court of that particular state? Are they proactively making sure that the state governments are doing enough to improve the judicial infrastructure at that level or not?
Yeah, so primarily the state government's budget for the district courts, but in the last 2 decades, the central government has been running many schemes in the form of e-courts and the centrally sponsored scheme for judicial infrastructure, where it shares the responsibility of budgeting for courts. And there has been a lot of public money spent on constructing courtrooms and building residential accommodations for judges. The state governments, in fact, have a very crucial role to play still. And this happens in coordination with the high courts and the judges at the district court level, because
Hmm.
the entire, the chain of which how the money flows, the district judge will. If you're talking in the context of a new courtroom, the district judge will float a proposal. It will be approved by the administrative
Administrative
committee
side.
of the high
Yes.
courts,
Yes.
and then the state government will primarily approve the money for it. The central government supports the state government fiscally, but it is execution wise, it is the
It's
responsibility of the state
state
government
government.
and the high courts combined.
Hmm.
So this process of coordination, in fact, takes a lot of time.
Okay.
And because the money is conditional, since the central government also demands accountability, the money is conditional on the state governments meeting a lot of requirements, and
Right.
sometimes judicial infrastructure is probably not their top priority.
Right.
And when state governments are fiscally weak, they cannot match the share that they have in the centrally sponsored scheme, and therefore the judicial infrastructure in that state is neglected.
Okay.
But those are larger problems with the fiscal federalism framework, and not really the responsibility of like the state government in particular.
Okay, well, thank you so much, Prashant and Chitrakshi, for joining us and talking about your book, which I am sure will, bring more focus on the state of the subordinate judiciary in the country, only for the reason because it continues and will continue to be the first point of contact for every litigant. And we just hope that the Tareekh Pe cycle doesn't continue forever. Thank you so much for joining us today. And thank you. I want to thank our viewers also for watching this show. Thank you so much.
Thank you so
Thank you
much
for
for
having
having
us.
us.
Thank you.